January 19, 2026, 4:47 p.m., Washington, D.C. A White House press release announced that the President of the United States had granted a full pardon to Henry Cuellar, former United States Congressman for Texas's 28th Congressional District. The pardon was effective immediately. The federal trial of Henry Cuellar and Gloria Cuellar was scheduled to begin on January 26, 2026, 6 days away. The jury pool had been summoned. The courtroom in Laredo, Texas had been prepared. The prosecutors in the Southern District of Texas had spent 20 months assembling the evidence. The defense teams had been in trial preparation for months. The classified exhibits had been through their security review. The cooperating witnesses had been prepared. One White House press release, 4:47 p.m., 6 days before the trial. The Department of Justice filed a motion to dismiss all charges against Henry Cuellar on January 20, 2026. The motion was granted. The case against Henry Cuellar ended. The case against Gloria Cuellar continues. A presidential pardon covers the pardoned individual. It does not extend to co-defendants. 20 months of federal investigation, one of the most significant congressional foreign bribery cases in Texas history. A jury pool already selected. A trial 6 days from beginning. One press release. This channel covers what the pardon stopped and what it could not stop. Subscribe now. The presidential pardon power is among the broadest and least reviewable authorities in the American constitutional framework. Article 2, Section 2 grants the president the power to grant pardons for offenses against the United States. No legislative approval is required. No judicial review is possible. The pardon is final. Henry Cuellar was indicted in May 2024 on bribery and conspiracy charges alleging that he and his wife accepted approximately $600,000 in payments from a Mexican bank and an entity connected to Azerbaijan State Oil Company, while Cuellar used his congressional position to benefit those entities' interests. The indictment was 70 pages of charging language describing a payment structure, a set of official acts, and a quid pro quo that federal prosecutors argued they could prove beyond a reasonable doubt. They were prepared to prove it in a federal courtroom in front of a jury starting January 26. The pardon granted on January 19th means that proof will never be offered in the case it was assembled for. The proof exists. It is in the case file. It is in the evidence exhibits. It is in the cooperating witness testimony. It is in the financial forensics. It is in the communications records. The pardon did not destroy the proof. The pardon removed the defendant from the proceeding. What the proof would have shown, what the jury would have decided, will never be known in the context of Henry Cuellar's criminal prosecution. The forensic detail from the investigation not previously highlighted. The cooperating witness in the Cuellar case is not among the individuals named in the indictment. They are referenced only as CW1 in the court filings. Their identity has not been publicly disclosed. Their cooperation agreement was executed in late 2024 and formed a significant portion of the evidentiary foundation for the government's trial preparation. CW1 is still alive. Their cooperation agreement is in the DOJ file. The agreement requires ongoing cooperation in related investigations, not just in the Cuellar proceeding. The pardon ended the Cuellar prosecution. It did not end CW1's cooperation obligations regarding related matters. CW1 is still cooperating. What they are cooperating about and with which investigation has not been publicly disclosed. What would you take from this case as the lead prosecutor? Type A if you believe the pardon power, applied 1 week before trial, fundamentally undermines the rule of law in federal corruption cases. Type B if you believe the pardon power is a constitutional feature that must be accepted even when its application is uncomfortable. The pardon's political context is inseparable from its legal effect. Henry Cuellar was a Democrat. Donald Trump, who granted the pardon in the weeks before his January 2020 inauguration, the pardon was January 19, 2026, which would be in Trump's second term. Trump was re-inaugurated January 20, 2025. So in January 2026, he had been president for 1 year. The pardon of a Democratic congressman by a Republican president, a congressman whose case involved allegations of taking payments from foreign governments, produced immediate and intense political commentary. The White House's explanation referenced the length of the investigation, the disruption to the Cuellar family, and the president's belief in second chances. The explanation did not address the specific foreign bribery allegations. It did not address the Azerbaijan or Mexican bank connections. It did not address the timing, 6 days before trial. The explanation is in the press release. The press release is in the public record. Its specific language will be examined by legal scholars and federal prosecutors for years. What makes a presidential pardon appropriate for a federal foreign bribery prosecution 1 week before trial? What criteria were applied? What review process preceded the decision? These questions are not legally reviewable. The president can pardon anyone for any reason at any time for any federal offense. The constitutional text does not require explanation. But the political and historical record will reflect the pardon. It will reflect its timing. It will reflect its context. Forever. Gloria Cuellar's trial is proceeding. Her defense will presumably argue, as Henry Cuellar's defense would have argued, that the payments she received were for legitimate consulting work and that any subsequent official acts by her husband were unrelated to those payments. The prosecution will have the same evidence assembled for the January 26 trial, the same financial records, the same payment tracing through Delaware shell companies, the same communications evidence, the same testimony from CW1. The same evidence, minus one defendant. The jury in Gloria Cuellar's trial will see the full scope of the alleged scheme. They will evaluate the payment structure. They will evaluate what the payments were for and what followed them. Henry Cuellar will not be at the defense table. But the evidence that was assembled to prove what he did will be in the courtroom. The pardon removed him from the proceeding. It placed the conduct he was charged with in the unique legal category of pardoned but never tried, not acquitted, not convicted, not dismissed for insufficient evidence. Pardoned. The category that says, the President of the United States chose to end this prosecution before the jury could speak. The jury was summoned, the courtroom was prepared, 6 days away. The jury will never speak about Henry Cuellar's case. They will speak about Gloria Cuellar's. Subscribe. Gloria Cuellar's trial is the next development. CW1's ongoing cooperation is the development after that. Subscribe so you see both. The trial preparation that was completed for January 26 represents 20 months of work by the prosecutors in the Southern District of Texas. That work does not disappear because of the pardon. It transfers to Gloria Cuellar's proceeding. It informs ongoing investigations. It lives in the case file. The Category C payments, the third payment stream, the unnamed foreign national, the $87,000 that was not part of the charge indictment, are still in the investigation file. The ongoing designation in the original indictment survived the pardon. CW1 is still cooperating. The category of cases where a congressional bribery prosecution ends by presidential pardon 1 week before trial is now a non-empty category. It was empty before January 19, 2026. It is not empty now. Henry Cuellar's name is in that category. One White House press release, 4:47 p.m., 6 days before the jury was to hear the evidence. The evidence is still in the case file. It will be in Gloria Cuellar's trial. The jury that was summoned for January 26 went home that evening. They were dismissed when the DOJ filed its dismissal motion. They do not know what the evidence showed. They never saw it. The courtroom in Laredo was prepared. The exhibits were organized. The witness list was finalized. One press release. The courtroom was unprepared. The exhibits were archived. The witness list became Gloria Cuellar's case. January 19, 2026, 4:47 p.m. 6 days. The pardon is in the White House records. The evidence is in the Southern District of Texas case file. CW1 is cooperating. The trial is still coming. Just without Henry Cuellar at the defense table. Gloria Cuellar will be there. The evidence will be there. The jury will speak. Not about him. About the scheme. The scheme that a pardon could not undo. The specific legal mechanism that makes Gloria Cuellar's continued prosecution possible while Henry Cuellar's was terminated is worth understanding. A presidential pardon is personal. It attaches to the individual named in the pardon instrument. It does not attach to the conduct, to the scheme, or to other participants in the conduct or scheme. When Henry Cuellar was pardoned, the government's case against him ended. The pardon removed his criminal liability for the offenses charged in the indictment. It did not affect the evidence, it did not affect the investigation, and it did not affect the prosecution of his co-defendant wife, whose criminal liability is independent of his. This structural feature of the pardon power means that the prosecution's evidentiary work, everything assembled for the January 26 trial, retains its legal value and utility. It can be used in Gloria Cuellar's trial. It can be used in any investigation of related conduct. It can be referenced in any future prosecution of individuals connected to the scheme. The pardon created a defendant-shaped hole in the case, not an evidence-shaped hole. The evidence is intact. Gloria Cuellar faces the same charges her husband faced, minus the specific official acts tied to Henry Cuellar's congressional position. The charging framework for her case focuses on her receipt of the payments, characterized in the indictment as bribes, and her role in the scheme's financial structure. Her defense will argue the payments were legitimate. The prosecution will argue they were not. The jury will decide. That decision, which a jury would also have made about Henry Cuellar, is now entirely Gloria Cuellar's to face. The pardon shifted the legal weight. It placed the entire burden of the jury's judgment on one defendant instead of two. Whether that is more or less fair to her than proceeding with both defendants is a question with no clean answer. What is clear, the evidence that was assembled to prove what both of them allegedly did will be presented to prove what she allegedly did. The jury will draw whatever conclusions the evidence supports. The 20 months of work by the Southern District prosecutors is not wasted. It is redirected. CW1 is cooperating. The Category C investigation is running. Gloria Cuellar's trial is coming. What does justice look like in a case where one defendant was pardoned 1 week before trial and the other was not? That is the question this case leaves open. Not a legal question, a normative one. The law permits the pardon. The law permits the continued prosecution of the co-defendant. The law will produce a verdict in Gloria Cuellar's case. The normative question, whether the use of the pardon power in this specific context represented justice, political calculation, or something in between, is not answered by the legal process. It is answered by the public record, and the public record will include the January 19, 2026 pardon, 4:47 p.m., 6 days before trial. The January 20th dismissal motion. The January 21st court order granting the dismissal. The jury that was summoned and sent home. The courtroom that was prepared and then unprepared. The trial that did not happen. And the trial that will. Gloria Cuellar's case is proceeding. The evidence is there. CW1 is cooperating. The courtroom in Laredo will be prepared again. This time, the trial will begin. Subscribe. The trial date for Gloria Cuellar will be announced. This channel will cover it from opening statements through verdict. One White House press release, one paragraph, one name. 6 days. The scheme that the pardon covered is in the evidence file. Gloria Cuellar will face it in court. The jury that was summoned for January 26 went home. A new jury will be summoned. They will see the evidence. They will speak about the scheme, about the payments, about the Delaware shell companies, about the Mexican bank and the Azerbaijani oil company, about everything that was assembled for January 26 and never presented. A pardon covered one defendant. The scheme is not covered. The scheme goes to trial. Without Henry Cuellar. With his wife. With the evidence. With the jury. The courtroom will be prepared again. 6 days became open-ended. But the trial is coming. The Laredo Federal Courthouse, where the trial was scheduled, has hosted dozens of significant federal cases. Drug trafficking prosecutions, cartel money laundering cases, human smuggling operations. The Southern District of Texas is one of the busiest federal districts in the country by caseload, largely because of its geographic position on the U.S.-Mexico border. The Cuellar case would have been the most prominent congressional foreign bribery prosecution in the district's history. A sitting member of Congress, one who had represented this specific border region for 20 years, facing trial for accepting payments from a Mexican bank while using his congressional position to benefit that bank's regulatory interests. The trial would have drawn national coverage. The classified exhibits would have required security accommodations in the courtroom. The cooperating witness testimony would have been among the most detailed public accounts of how foreign entities use congressional relationships for commercial and political purposes. None of that happened on January 26. The coverage happened. It covered the pardon. The classified exhibits are in the evidence file. CW1 gave their account to prosecutors, not to a jury. At least not yet. Gloria Cuellar's trial will produce a courtroom proceeding. It may not produce the full scope of what the January 26 trial would have addressed. Without Henry Cuellar as a defendant, some of the official act's evidence that requires his specific conduct will be less central. But the core of the scheme, the payment structure, the shell companies, the financial forensics, will be there. The jury will have most of what the January 26 jury would have had. Not all of it, but most. That is what remains after a pardon removes one defendant from a two-defendant case. Most. CW1 is cooperating on related matters. The Category C investigation has the $87,000 in the unnamed foreign national and the third intermediary. The DOJ's investigation of the Cuellar network, because it was always a network, not just two individuals, continues under its own momentum. The pardon is not the end of this case. It is a specific event in the middle of it. The trial did not happen on January 26. The trial will happen for Gloria Cuellar. The investigation continues for Category C. CW1 continues for related matters. The pardon is January 19, 2026, 4:47 p.m., permanent. The evidence is in the case file, permanent. The trial is scheduled, coming. 6 days became open-ended. The jury will be summoned again. Not for Henry Cuellar, for Gloria Cuellar, for the scheme. Subscribe. When the trial date is announced, when the jury is summoned again, this channel will have the full coverage from day one. January 19, 2026. One press release. 6 days. The trial is still coming. There are two categories of outcome for a federal prosecution: resolution through legal proceedings or termination before those proceedings conclude. Acquittal, conviction, and dismissal for insufficient evidence are legal resolutions. A presidential pardon 1 week before trial is something different. It is a termination before resolution, not a finding of innocence, not a finding of guilt, a presidential decision that the proceedings should not continue. The distinction matters for the public record. An acquittal says the evidence was insufficient to convince a jury. A conviction says it was sufficient. A presidential pardon says neither. It says the president chose to end the prosecution. The indictment that was dismissed on January 20th is in the Southern District of Texas's court filing system. It describes the alleged conduct in 70 pages of charging language. That description is in the public record, permanently. The description in the indictment is not a verdict. It is an allegation. Legally, Henry Cuellar was never convicted. The indictment, now dismissed, is not proof of anything under the law. But it is a document in the federal court record describing specific alleged conduct by a named former congressman in specific detail. The pardon cannot remove that document from the record. The document will be there when historians examine this period of American political history. It will be there when journalists reference the Cuellar case. It will be there when legal scholars analyze the use of presidential pardons in congressional corruption cases. The pardon exists in that same record. 2 documents, 1 indictment, 1 pardon. The indictment says what was alleged. The pardon says what the president chose to do about it. Both are permanent. Neither is a verdict. The only verdict in this case will be the jury's in Gloria Cuellar's trial. That verdict is coming. Subscribe. This channel will be there for the jury selection, the opening statements, the verdict, and the sentencing if there is one. January 19, 2026. 1 White House press release. 6 days. The indictment is in the Southern District's records. The pardon is in the White House records. The evidence is in the case file. Gloria Cuellar is going to trial. CW1 is cooperating. Category C is open. The jury will be summoned again. They will see the evidence. The evidence does not know there was a pardon. The evidence is just the evidence. It will be presented. And the jury will speak. About the scheme. About the money. About what it purchased. 1 week before the jury was to speak about all of it, for both defendants, there was a press release. 4:47 p.m. 6 days. Now it is Gloria Cuellar's jury that will speak. And when they do, this channel will be there.